In this video, we're going to be continuing our discussion about registered land. And we've had a look at the land register and what we could find on the land register. And in particular, we've had a look about how we can protect our interests on the land register through registrable dispositions. And in this video, we're going to be looking at the effect of rights in rem on disponees. Is to cover not only the transferee of the freehold, but also individuals who take rights smaller than the freehold over a registered estate. For example, that might be a lease, a charge, or an easement. You'll see that there are contests not only between the purchase of the freehold and holders of the pre-existing rights in rem, but also between two parties who hold rights in rem smaller than the freehold over the land. Quite often these contests are between a holder of a pre-existing right in rem, such as the beneficial interest under trust, and a mortgagee bank who also takes a right in rem over that same freehold. The question is whether the bank is bound by the pre-existing right in rem, and that's what I'm going to cover in the next video after this one. So we basically want to know whether the person who takes a smaller right in the land is bound by a pre-existing right in rem, as this may affect what they can do on the land. So this is the key statutory provision, the Land Registration Act 2002, section 29, and I'll read it out. So subsection 1, if a registrable disposition of a registered estate is made for valuable consideration, completion of this disposition by registration has the effect of postponing to the interest under the disposition any interest affecting the estate immediately before the disposition whose priority is not protected at the time of the registration. And in subsection 2, for the purposes of subsection 1, the priority of an interest is protected in any case if the interest is a registered charge or the subject of a notice in the register, or falls within any of the paragraphs of Schedule 3. So Section 29 here is a bit like Section 27 in that it is fairly impenetrable, but it is absolutely essential that we understand it. So I'm going to help break down this provision so you can understand it a bit more clearly, because this probably is a little bit confusing. So let's break this down. So the first part says, if a registrable disposition of a registered estate is made for valuable consideration, completion of the disposition by registration has the effect of ... So registrable disposition of a registered estate. This links into section 27, which lists those registrable dispositions of a registered estate. For example, the transfer of the freehold is a registrable disposition, the grant of an easement is a registrable disposition, and the grant of a lease of over 7 years is also one of our registrable dispositions. And then we've got the idea of valuable consideration. So this is just simply put money, okay? For example, if an easement is granted, which is one of our registrable dispositions, in exchange for money, then that would be valuable consideration, okay? And then completion of the disposition by registration. So for example, if the disposition in question is the grant of an easement, you can register it under the charges register of the burdened freehold, okay? And if the disposition in question is, let's say, the transfer of the freehold, then you can complete the disposition by registering the new owner of the freehold as a proprietor. From section 27, registering as a registrable disposition means that the interest under the disposition achieves legal status, as registration is a substantive formality requirement for these legal rights in rem. So once the disposition in question is registered and all the boxes are ticked, it will then have the following effect. So it has the effect of postponing to the interest under the disposition any interest affecting the estate immediately before this disposition whose priority is not protected and at the time of the registration. Okay, so what this means is that we can break this down into the following aspects. So the interest under the disposition, so the dispositions under section 27, such as the grant of the easement. Okay, so this is talking about the actual disposition, that is one of the dispositions that's listed under section 27. That is the right in rem which has been transferred or granted, and the interest itself is the right in rem. And I urge you to look at my video on interests and legal and equitable interests from another video that I did early on in my land law course. And the priority is not protected, okay? So the new interest will take priority over any pre-existing interest, rights in rem, whose priority is not protected. So just note that the word postponing here means that the new interest will take priority. On the corollary, the new interest will be bound by any pre-existing right in rem whose interests are protected. Look, I know this can sound a little bit complicated and confusing, but don't get too bogged down by the language, as it can be a little bit intimidating. All we need to do is work out whether the priority of a pre-existing right in rem has been protected. If it has, then the new interest holder is going to be bound by it. If it hasn't been protected, then the new interest holder will take free of it. Okay, so everything hinges on whether the priority of a pre-existing right in rem has been protected. Okay, and that leads us on to section 29, subsection 2 of the Land Registration Act 2002. Okay, so for the purposes of the section we just saw, the priority of an interest is protected in the following cases. Okay, if the interest is a registered charge or the subject of a notice in the register, or falls within any of the paragraphs of Schedule 3. We looked at notices in the previous video and how you can register a charge on the charges register. And in the next video, we will look at the Schedule 3 of the Land Registration Act 2002. Okay, so we're now going to look at an example of how these provisions operate in practice with a Blackacre example. So Claire is the registered proprietor of the registered freehold estate in Blackacre. In 2004, she and Liam enter into a written agreement describing itself as a deed, granting Liam the right to use her driveway in order to access his house. The agreement is validly executed as a deed by both Claire and Liam. In 2008, Claire sells the land to Polly for market price, and she is duly registered as proprietor of the freehold estate. Polly is concerned about Liam's use of her driveway. He drives far too fast, and she is worried about the safety of her young children, who often use the driveway for their games. Advise Polly. Now, for the purposes of this question, you can assume that 1. The right Claire grants Liam satisfies the law's content requirements for an easement, and 2. That Liam's interest does not fall within any of the paragraphs of the Land Registration Act 2002 Schedule 3. Okay. Now the first thing is that this is to do with registered land. We are dealing with a registered freehold estate in Blackacre. So that tells us our governing statute is the Land Registration Act 2002. So that is what we need to look at to determine the impact of the rights in rem on disponees. The best approach is to start with the practical significance of the question, and that is that Polly is concerned with Liam using her driveway and she wants to stop him from doing so. If Liam's right over Blackacre binds Polly, so if it takes priority over Polly, then she won't be able to stop him from using her driveway. On the flip side, if the right doesn't bind Polly, then she will be able to get her own way and prevent Liam from using the driveway in the future. Okay, so does the right which Liam has over the freehold estate of Blackacre take priority or bind the right that Polly takes? Well, firstly, we want to know what the right is which Liam has over Blackacre, because we need to categorise that right in order to work out its impact on disponees of the land. The passage here tells us the right satisfies the content requirements for an easement. The only remaining step is to consider formalities. We're doing this because we know an easement is a right in rem that is potentially legal. That's section 1 of the Law of Property Act 1925. And we want to know if it is actually legal. And as we are dealing with registered land, for it to be legal, we need a deed, and it must be a registered right. That is, because the grant of an easement is one of the registrable dispositions under section 27. Okay, so we need it to be a deed, and it must be registered. Now, we've not been told that the right is registered. Nothing says here that Liam's right is registered under Blackacre's charges register. Therefore, there is no legal easement. So we go on to the next step in our inquiry to see if there is any effect in equity. So here, although we have a failed legal easement, the law will construe there is a valid contract to confer an easement provided that the requirements of the Miscellaneous Provisions Act section 2 are fulfilled. In other words, the agreement is in writing and signed by both parties and incorporates all relevant terms. So we will be able to salvage some effect from this easement. Claire sells the freehold, and we know a transfer of a registered estate in land is a registrable disposition. So in order for the transferee to take a legal effect, there needs to be registration. We are also dealing with section 29 of the Land Registration Act 2002 here. This tells us that there must be a registrable disposition of a registered estate, and it is made for valuable consideration and must be completed by registration. Now, here we have a registrable disposition of a registered estate. We have a transfer of the freehold. She pays valuable consideration, as we are told Polly pays market price for the freehold. And Polly is subsequently registered. So there is a completion of the disposition of the registration. So our hypothetical clause is satisfied here. The law says that if the above requirements are fulfilled, then the new interest takes priority over any pre-existing rights in rem whose priority has not been protected. If the priority of a pre-existing right in rem has been protected, then Polly will be bound by those pre-existing rights in rem. So it's going to hinge on whether on the protection of pre-existing rights in rem. So Liam's right here. This is what it all hinges on. We found out before that Liam has an equitable easement. We categorised his right as an equitable easement just a few minutes ago. Section 29 subsection 2 of the Land Registration Act tells us you can protect the priority of a pre-existing right in rem if it is either registered or falls within Schedule 3. We are told that Liam's pre-existing right in rem does not fall within Schedule 3, so his priority will only be protected if it is subject of a notice on the register. And we know that it is not registered, so Liam's right is not protected, and Polly takes free of it, which means Polly can stop Liam using her driveway. In other words, she is not bound by his right in rem. Okay, so you can see that is quite a long-winded answer, but those are the logical steps that you really need to take to try and tackle these sort of problem questions. I'm going to give you another one now to see whether or not this is coming in, like if you're actually understanding what I'm trying to say, understanding the processes and understanding the law itself. So Blackacre example 2. Claire is the registered proprietor of the registered freehold estate in Blackacre. In 2004, she executes a valid deed granting Liam the right to use her driveway in order to access his house. The right is duly registered on the charges register of Blackacre's title. In 2008, Claire grants Polly a 10-year lease over Blackacre in return for a monthly payment of £2,000. This lease is granted by deed and registered on the charges register of Blackacre's title. Polly is concerned about Liam's continued use of Blackacre's driveway. He drives far too fast, and she is concerned about the safety of her young children, who often use the driveway for their games. Advise Polly. For the purposes of this question, you can assume that the right that Claire grants Liam satisfies the law's content requirements for an easement. So Polly does not want to be bound by Liam's pre-existing right. That's the same as we saw in the example just a moment ago, in example 1. And she wants to stop him from using the driveway. Whether she can or not depends on whether Liam's interests bind and take priority over her own. In this case, we do have a valid legal easement as there is a deed and registration exists. So let's look at the second paragraph. We now want to know whether Liam's right to use Blackacre's driveway takes priority over Polly's lease. Now, Polly's lease is 10 years and has been granted by deed and registered, so has legal status. It is a legal lease over the land, according to the law, the Law of Property Act 1925, combined with Section 27, as it is a registrable disposition. Now, Section 29. If we look at Section 29, we now want to know the impact of Liam's easement on Polly's lease. In other words, we want to know which takes priority. The hypothetical clause in Section 29 is if there is a registrable disposition of a registered estate for valuable consideration, then completion of the disposition by registration has the following effect. So we have got a registrable disposition here, and we have valuable consideration. So once the lease is registered as it is, the following effect happens. The effect is that the pre-existing rights in rem whose priorities is protected will bind/take priority over the new interest, that is Polly's interest. But pre-existing rights in rem whose priority is not protected will be postponed to Polly's interest. So Polly's interest will trump them and take priority, essentially. So again, we need to ask whether the pre-existing rights in rem have been protected, and this will simply be this will be simple if we look at Section 29, subsection 2. Okay, so this tells us that the priority of an interest is protected if the interest is subject to a notice on the register. And here we are told that Liam's right has been duly registered on the charges register of Blackacre, of Blackacre's title. So by virtue of that registration, its priority has been protected. The easement will bind Polly's subsequent rights in rem, her subsequent 10 years lease, and there's nothing she can do about Liam's continued use of the driveway. Okay, so I would probably go over those two examples again, just so that you really do understand those logical processes, because that is the exact way you want to be answering a problem question in your exam. It takes it through logically through the statute provisions, that's the statutory provisions, and ties it in nicely with the facts of the problem question itself. Now, the Land Registration Act 2002, Section 28 says the following. Except as provided by Sections 29 and 30, the priority of an interest affecting a registered estate or charge is not affected by disposition of the estate or charge. It makes no difference for the purposes of this section whether the interest or disposition is registered. So put more simply, whether Section 29, Section 30, Section 29 and Section 30 of the Land Registration Act 2002 do not apply. So when that does not apply, a disponee of land is affected by any pre-existing rights in rem, regardless of registration. Okay, so this will rarely be engaged as Section 29 is the key provision, but it will be engaged in some cases when Section 29 is not engaged. So if there is some reason why the hypothetical clause, the if clause in Section 29 cannot be satisfied, then your analysis of the priority of rights in land is going to be governed by this provision in Section 28. Now, I understand that this section is expressed again in terrible language. I mean, a lot of legal provisions really are. It's quite awful, but Section 29 basically says that when Section 29 does not apply, a disponee of land is affected by any pre-existing rights in rem. So let's look at one final answer, one final problem question just to finish off this video, and it's a slightly smaller one. So Claire is the registered proprietor of the registered freehold estate in Blackacre. In 2011, she grants her next door neighbour, Liam, an option to purchase Blackacre at a reduced price. The grant is formalised in a document signed by Claire, but the option is not registered on the Charges Register of Blackacre's title. 2 years later, Claire transfers Blackacre to her sister Lily for the nominal sum of £10. Lily is duly registered as proprietor of Blackacre. Liam now wishes to exercise his option and seeks your legal opinion as to whether it is enforceable against Lily. So an option to purchase is an equitable right in rem, as it does not fall within the list contained within the Law of Property Act, Section 1. And the formality for the valid conferral of an equitable right in rem is different from the formality requirements for the valid conferral of a legal right in rem. So the Law of Property Act Section 53, subsection 1 tells us equitable rights in rem must be created by signed writing. If it is not created by signed writing, you have failed to confer a right in rem. But the option to purchase is not registered, and we know it can be registered, as all rights in rem can be registered against the estates they burden, apart from those explicitly exempted. So, for example, beneficial interests under trusts or the short leasehold, as stated in Section 33 of the Land Registration Act 2002. Now, the transfer of Blackacre is a registrable disposition, but it was not for valid consideration. They only paid a nominal sum. So Section 29 is not engaged, so we cannot apply the priority rule under Section 29. So where the priority rule of Section 29 cannot be applied, we have to apply Section 28, which we just looked at. And because Liam's option arose before the disposition, it is going to bind Lily, regardless of the fact that it has not been registered and does not fall under Schedule 3. So that really caps off this video about the effects of rights in rem on disponees, and it really covered the first aspect where the priority of an interest is protected if that interest is a registered charge or the subject of a notice in the register, and exploring Section 29 of the Land Registration Act. And now in the next video we're going to be looking at the second aspect where the priority of an interest is protected if it falls within any of the paragraphs of Schedule 3. So if you have any questions about that, because I know that could be quite complicated and difficult, I'm more than happy to answer any questions you may have. Just leave a comment below. And if you like the video, make sure you give it a thumbs up and make sure you subscribe. And yeah, I look forward to seeing you next time. Thank you very much.